Well, hey folks, Bill O'Leary. And in this video, I'm going to be talking about the question of Medicaid estate recovery and what it is. So you're going to learn three things in this video to start off with. One, what is Medicaid? Two, what is Medicaid estate recovery? And three, is there any part of your estate that is excluded from Medicaid estate recovery? Again, my name is Bill O'Leary. I am a lawyer. Estate planning is what I do, elder law, probate, and trust administration. And my firm is Legacy Planning Law Group in Jacksonville, Florida. So let's go ahead and dive in. So Medicaid, first of all, it's a combined federal state program that helps, among other things, to pay for long-term care costs. Now, just because somebody gets qualified for Medicaid and for the benefit, it's not a free lunch, unfortunately. There's a price to be paid, and that price is after they die with what we call Medicaid estate recovery. Now, the money that Medicaid pays on behalf of a Medicaid recipient, it's really a debt that is owed back to the state. And while the Medicaid estate recovery program doesn't sort of kick in until after death, so it doesn't affect the eligibility while you're alive, it does kick in after death. And so this is where Medicaid can come in and file a claim against your estate to try to get reimbursed on behalf of the taxpayer for the benefit monies that were paid out. Now, how does the state of Florida know that a person that was receiving Medicaid has died? How do they know? Well, there are various sort of government agency relationships and reporting sort of lines of communication. First of all, the Social Security Administration is going to tell Medicaid. And on the state level, the Office of Vital Statistics, this is where you get a death certificate, they are also going to share information with Medicaid about a deceased person. Now, not only will Medicaid learn about the death of a Medicaid recipient from government agencies, but Medicaid has to be notified when an estate is open. Florida law requires the executor of the estate to notify all creditors that an estate has been open. And by the way, Medicaid is a creditor if the deceased individual had received benefits from the Medicaid program. So Medicaid is a creditor in that situation. So as long as the person that was receiving Medicaid was age 55 or older, the executor of the deceased person's estate has to send a notice along with a copy of the death certificate to the Florida Agency for Healthcare Administration. We call it ACA for short. Then Medicaid is going to determine whether it provided any medical assistance to the deceased person. And if it did, Medicaid will file a claim with the probate court saying, hey, there were benefits paid out, and this is the amount that is owed back to us from the deceased person's estate. The clerk of the court is then going to forward a copy of that claim to the estate attorney. In addition, the state obtains copies of reports by the each county's what's called the clerk of court, which lists the estates that were open during the previous month. Estate information is matched then against the list of Medicaid recipients, and where appropriate, again, a claim is filed in the estate by Medicaid. Now, importantly, the state of Florida does not file a claim where the Medicaid recipient is under age 55 at the time of death, or where the Medicaid recipient, let's say, leaves a surviving spouse, a minor child, or a child who is blind or disabled. Any claim that's filed by Medicaid in the estate of a deceased Medicaid recipient, that claim only includes the benefits paid for services rendered after the recipient reached age 55. So if there was an overlap, any benefits paid before 55 can't be subject of the claim, but after 55 they can. Now, a deceased Medicaid recipient's assets are used to pay the expenses of administration as part of the estate, other obligations, and there's a certain order that those have to be paid. So first, there are the expenses of administering the estate, like court filing fees and attorney's fees, and then after that, the estate, have to pay for the funeral and burial expenses. There's often a limit there, but after those expenses are paid, then the Medicaid claim has to be satisfied. So the Medicaid claim is fairly high up. There's actually an ordering of 8 different classes, and Medicaid is fairly high up on that list. And the thing is that Medicaid has to be paid, reimbursed, before the lower class of creditors are addressed. Now, the personal representative of an estate, and in fact, any heir for that matter, they can request that Medicaid, that the agency actually waive estate recovery if it's believed that enforcing that claim is going to cause an undue hardship. A request for a hardship waiver form can be obtained, and all you got to do is contact the Florida Medicaid Estate Recovery Program. And once that is received by Medicaid, the completed form is received, and there's enough sort of supporting documentation, the agency may or may not grant a waiver of the estate recovery right that Medicaid has. And the agency is going to consider a number of things. For example, whether this particular family member or heir would be deprived of, let's say, food or clothing, shelter, necessary medical care, and so forth, in order to maintain their life or their health. So it's got to be a pretty serious situation, almost to the point of being destitute. The agency, in considering a waiver request, will also consider the decedent's children or siblings to the extent that they provided full-time care, which may have delayed the Medicaid recipient entering into a nursing home. So again, that would have saved money for the state. So that's another criteria the state will consider. By the way, hardship does not exist just because estate recovery would prevent the heirs from receiving an inheritance they would otherwise expect. That's not a good enough reason. One last thing, this is a question we get asked a lot. Can Medicaid take the home? The short answer is no. That's the good news. At least here in Florida. By the way, in other states, that state's Medicaid can take the home, not so in Florida. So as long as the Medicaid recipient owned the home and was using it as their primary residence before moving into the facility, then it would be considered what's called a protected homestead, and is protected from creditors, including Medicaid, which means nobody can force the sale of the house, not even Medicaid. Now, note that any real property that is not considered the homestead, so think a second piece of property, vacation home, rental, that likely would have to be sold off in order to pay Medicaid on the claim. Again, all part of Medicaid estate recovery. So if you'd like to know a little bit more about what Medicaid estate recovery is, and hey, maybe how we could help, we'd love to talk to you. So we invite you to go ahead and book a free 15-minute discovery phone call. Just go to our scheduling calendar. Just go to the link below this video, click on it, takes you right to our calendar. Pick a day and time that works for you. If you've enjoyed this video, please like it. And also, if you're not already a subscriber to our YouTube channel, please do so, Legacy Planning Law Group. So I hope you've enjoyed this little video about Medicaid and the estate recovery program. So this is Bill O'Leary signing off for now. Go make it a great day and a better world.